commence in a minute now. Good morning, one and all the esteemed colleagues and all the members, fellow members of the legal fraternity. Thank you so much for joining us here today on Sunday Law Bulletin. It's truly an honor for us today because we have with us a remarkable figure, Dr. Ashok Yende, sir. Before we commence with sir's introduction, let us give the newcomers a brief introduction about Lawyers Development Forum. I hope I'm audible and visible. Yes, sir. Lawyers Development Forum promotes interest in the legal field by organizing academic lecture series and sports activities for advocates. These include cricket matches and badminton tournaments. The forum also hosts conferences featuring esteemed judges and speakers, providing valuable guidance and insights. Additionally, we host the Weekly Sunday Law Bulletin, which you all know, and where experts from various legal specializations share their knowledge and address key topics of importance. Today, we have with us an esteemed dignitary and a great lawyer, a senior advocate, Dr. Ashok Yende, sir. He would be sharing his insights on the topic, reshaping the legal profession, the impact of ADR and artificial intelligence. For this particular endeavor, we are particularly grateful to Advocate Dr. Rajendra Anbhule, sir, Advocate Vijay, Shelar, sir, and Advocate Abhishek Jagtap, sir. And we would like to express our sincere gratitude to all of them for initiating this remarkable project. Before we commence with Sir's session, here's a very important brief introduction from Sir, who he is, and it would be really a great honor to introduce him. It gives me great privilege to introduce a remarkable figure in the Indian Legal Academy, Dr. Ashok Yende, sir, whose dedication to the legal profession spans over 4 decades. Yeah, Dr. Yende, sir, brings exceptional academic excellence with LLB, LLM, PhD, DLit degrees, beautifully complemented by prestigious executive education from Harvard Kennedy School and London Business School. His illustrious career includes serving as professor and head of law at the University of Bombay and as founding director of Mumbai Law Academy. Today, he continues to inspire as the founder managing partner of Yende Legal Associates and Lokpal of Maharashtra National Law University, Mumbai. Dr. Yende's expertise is recognized at the highest levels. He is an empaneled mediator with the Supreme Court of India and Bombay High Court, and plays a vital role in SAMA, the Ministry of Law and Justice's pioneering online dispute resolution platform. His global stature shines through his role as the president of Global Vision India Foundation, which holds consultative status with the United Nations, representing India with distinction at the international forums in Vienna and New York. A prolific author of 7 books, his acclaimed work, Medicine and the Law, carries the distinguished forward by Honorable Chief Justice B.R. Kavai, sir. Dear colleagues and esteemed legal friends and fraternity, please join hands in welcoming me, sir, here, and let us look forward to his session, sir. Sir, you may now kindly proceed. I will be turning off my video and I'll be muting my mic. In case there's any hiccup, I will help you through it, sir. You may proceed, sir. Thank you so much, sir.
Thank you, madam. Such a kind words and my introduction. And it's a really pleasure to join this interactive session on Lawyers Development Forum. Particularly, I really appreciate and thank our friend Advocate Dr. Rajendra Anbhule, who and his team who invited me for this sharing my thoughts, and his team Advocate Vijay, Shelar, Advocate Abhishek, Jagtap, Advocate Ruchi, and other team members. And really, this type of the platforms are needed because the law is changing. Law cannot always be dynamic. Is always a dynamic, and naturally, according to change in the circumstances, there is a paradigm change and paradigm shift in the legal education and consequently legal profession. So I truly appreciate Advocate Anbhule sir for remarkably organizing this organization, and not only that, but event, but meticulously planning, and how continuously he was in touch with me and to provide for the meaningful exchange to the participant, which may include young lawyers, maybe law students, and some of the faculty members. So it's a really great honor to be here on this platform of the Lawyers Development Forum. Now, as everybody knows, because either students or the faculty or the young lawyers are there, they are aware there we got independence and a very nice document, a wonderful document called a document after we got independence on 15th August. And then headed by expert committee headed by Dr. Basa Ambedkar and Constituent Assembly headed by Dr. Rajendra Prasad. And but we adapted Anglo-Saxon system basically in our common law. We call it common law system in this English system. And with all these even dress code, many words we adapted. And with this network of the professionals, it is next to United States, one of the biggest network after the United States, around 25 lakhs of the registered advocates, and in Maharashtra probably I think 2 lakh 50,000 advocates are registered. And recently, Bar Council of India pronounced that there are more than 2,000 law colleges, mushroom growth of law colleges, and that's why they have declared moratorium for the 3 years, so that there should not be permission for any law college, because with the Bar Council and the university, they want to maintain a particular standard of the education. So with, and the Advocates Act is the only act which regulates the legal profession. So with this, briefly, the changes in the legal profession in this country, there are a lot of changes after the coming into force of the 5 years course, we call it interdisciplinary course, and then consequently the artificial intelligence or technology. So it has a great impact on this legal profession. And I think these two things, one is technology, and then ADR and artificial intelligence, it has got a great impact on this legal development of the legal profession. Now, one of the best justice system in this country, in spite of I just mentioned that best constitution, best justice system, big great judges and legal professionals and legal institutions in this country, but unfortunately we have got pendency of more than 6.5 crores of the cases. That is on judicial side, up to lower court to the higher side, and then non-judicial side probably 3 crores cases are there. So along judicial and non-judicial side, we will find there are more than 10 crores of the over 10 crores of the cases pending. It shows the very unfortunate this scenario of this country, and somewhere we are lacking, and we should find the solution, and some remedial measures are there. And the only way I feel is that alternate dispute resolution and IT or this artificial intelligence is the only way out which can help us to mitigate this particular solution. That's why from that angle, today's topic is very relevant from legal education point of view, legal professional point of view. Now, whenever new innovation new technology comes, everyone knows, we all will agree with me that there is a lot of opposition. When Aadhaar card came, there are a lot of cases where there are cases were filed up to the Supreme Court, right? Putta Swami's case, 9 judges bench of the decision, right to privacy, it was related to the Aadhaar card. Then many agitations were there when Uber came in this country, e-commerce came, Amazon came, many platforms came, online education, Zoom, or rightly where I am now, we are connecting. So all the Google Meet is there. So all these, whenever these new innovation and technological advances are there, you will find a lot of opposition is bound to be there, because people are scared about this job, employment, and all these things, and earnings, and all these things are there. But whatever may be the situation, the government and the system has to act, accept that, adopt that particular system, because in Uber was there, a lot of strike was there all over the country, nationwide strike was there. And with same with the other instances, but you will find government accepted that, because there are global developments are there, and government has no other option but to accept that, because it is for the development and for the supportive system. So that is how things happen. Same thing will happen when in RT, the artificial intelligence or the information technology comes into play, joint hands with the law profession. A lot of opposition is there. Many advocates and the students are scared whether it will affect their legal profession as such. But it will never happen. We'll come to that point. It is how it is supportive and collateral to the legal profession. Now, artificial intelligence, everybody knows that it is totally reevaluating, totally changing the legal space of the legal profession, because it is something different than the physical practice. It is automatic routine tasks are there, enhancing legal research work is there, enabling predictive analysis is there. And many advocates and the law firms are increasingly adapting this legal artificial intelligence in the legal profession. So artificial intelligence is reshaping not only legal profession, but a client interaction, meeting the client interaction, interacting with the clients, how to extract the information. Chatbot is there, virtual legal assistants are there. Now virtual managers are there, and everybody, probably all the young people are there, they are aware that they are also appointing the virtual managers, and all this is becoming component of the legal profession. Now, when Justice Chandrachud, particularly when former Chief Justice of India, he declared and he made it mandatory that there will be virtual courts, e-filing has been made mandatory. Of course, in some cases where internet problem is there, then it can be in the hybrid mode. But when virtual courts come, now e-filing, virtual courts, virtual hearing, virtual settlements, it has become a part of the legal profession. It has made mandatory. So a lot of different thought was there whether it will affect the legal profession or like that. But now it has been made a part of the system and it has been made mandatory. And probably all of you practicing lawyers probably must be using all these things. Now, artificial intelligence is a term originally coined in 1955 by Lord McCarthy. Now, Lord McCarthy, this Mr. John McCarthy propounded this particular concept. He declared in the open conference something, a new invention, and this type of something is there called as machine learning or called as artificial intelligence. Then everybody was also scared and everybody was very doubting what will happen next like that. And he was also himself doubtful. In his own interview, he must have asked his own interview, founder of the artificial intelligence, he said he was also scared because of the ethical considerations, some ethical factors, and he said that this should not be misused. Probably it's good for the system. System will be efficient. Everything will be there. It will be fast, but it will be inexpensive. But he says that there are some ethical consideration and it should be used very cautiously. So this artificial intelligence coined by Mr. John McCarthy and subsequently developed to such an extent nobody thought about that. And then the most popular the platform probably the students may be using or the young lawyers may be using is OpenAI, we call Chat GPT, and from where we can extract most of the information. Now it has gone to different platforms. Many tools are there. This was the starting of Chat GPT by OpenAI. Now so many platforms are there, and sometimes paid tools are there where we can use artificial intelligence for different things, maybe for drafting, for data collection, for conducting the research. So different tools are there, but that was the starting point, beginning with the Chat GPT. And this concept of the artificial intelligence, basically, it is a branch of computer science that focuses for creating machines and software that can stimulate human intelligence. So ultimately, it is created by the human being. We have created that, but it is ultimately on the basis of the human intelligence. Their machines are working. So sometimes it is called machine learning also. So machine is working with the intelligence. That's why it's not a natural intelligence. So we call it artificial intelligence. Now this machine learning or the natural language processing, sometimes called, or the expert system predictive analysis, all these things are ultimately taking the basis is of the human intelligence. But it is based on the sensory system. Now human has got some senses. Students from biology is there. So they might be aware that we have got particular senses, and particularly the vision, hearing, the smell, taste, and the touch. So these senses actually goes to the all the universe, and it can be carried subsequently like radio station is there and frequency is caught, then we can be able to listen to that particular station. So it is a frequency and it is the sensation. So we have got the sensation. Vision had got the senses, hearing, smell. That's why this face reading is there. Face sensations are there. Some airports are there in the world where yes, we enter the airport and with the face recognition only you'll be able to permit it to enter the airport like that. So this body has got certain senses and it can be caught by that particular machine, and then they can predict accordingly. So there may not be 100% prediction because ultimately natural human being intelligence is something original human being, but they don't have the emotions, but it may not be 100% correct. But it will certainly help to draw the conclusion, draw the predictions, draw the data immediately fast. Probably it will take for the physical intelligence lot many of the years. So human AI interaction is something different. Now these advantages of this artificial intelligence for adapting in legal profession, and probably you may be aware that it increases the efficiency and the productivity. There are some 1000 pages are there. Probably it will take for us at least 1 or 2 days or 3 days for going through reading and analyzing the particular document. Probably within a minute or the second you just try, you will find that immediately data analysis is there. So that you can collaborate subsequently, support with your human intelligence, but within a minute or 2 minutes, entire data analysis will be there. Then cost reduction. If you go on xeroxing, printing, everything of thousands of the pages in legal profession, then you will find so much of the cost is there. So immediately on your computer and on that particular folder, you will get immediately all the data will be there. Naturally, it will, and then communication, going, travel, every expenses, all this you consider, you will find. This is a cost reduction in that sense. Then improved accuracy. So human error, there is always error to be there. You go to the bank, there is always cross-checking. So you will find always human error is bound to be there. And that's why it will be uniformity, there will be accuracy is there. So accuracy may not be 100%, but 90% there is a probability of the accuracy of the data analysis and the consistency. What a data will get in India, probably same data will be in America, all the England. So that can be one of the advantages. Then enhanced client satisfaction. Client will be satisfied. If you use so much of the documents, maybe I have seen in my law firm, there are so much of the heaps of the papers, so much of the papers are there being brought by the lawyers and the client. Then you will find that it takes a lot of time to go through all the papers, analyze them. And but in case of this, you apply the artificial intelligence technique, then you will find that immediately will be able to give client, this can be the predictability, this can be the situation, this probably may be the outcome in a particular case. The naturally client satisfaction will be there. He will be happy that within a day, lawyer or the advocates, concerned advocate could able to tell what may happen, may not happen like that, and immediately you could give the analysis of his own data. And this is the case, this is what we feel. So this is one of the advantages. Then addressing the burnout, it can elevate the burden of tedious work. You will find that practicing lawyers, maybe there are other faculty, so much of the tedious work is there, very difficult to sort out all the papers and the documents and the data and come to the conclusion, and of course with some errors is there. Now particularly cybercrime, you will find that is very difficult unless there is technology is there. You must have gone through the various courses, you must have gone through the master's course in cybercrime, you must have learned the definition of the cybercrime, historical genesis of the cybercrime, your theoretical conceptually cybercrime. But actually detection of the cybercrime requires the technology and artificial intelligence. It's not so easy. So with detection of the cybercrime, that's why in India you must be aware that there is hardly 1% conviction is there. So in Parliament, Ministry has stated there is a 3% conviction. But whatever I have discussed with the cybercrime expert on our panel and in our discussion, they mentioned that it is only 1% conviction. So you understand, with so much of the courses, so much of the legal institutions providing imparting education in cybercrime, you will find hardly 1% conviction is there. And we are also dealing with some cybercrime cases. Neither the police station is properly detected, neither the judiciary is able to detect it, because it requires the information technology knowledge, IT knowledge, it requires the artificial intelligence knowledge. But with this, you can be able to detect the cybercrime because it has got extra territorial jurisdiction. Maybe from other country, Nigeria, somebody is operating. All these difficulties are now recently United Nations in December 2024 adopted an international convention of cybercrime. This is for the first time. I am fortunate to be part of the one of the panel member of that discussion, which happened in Vienna, Austria. It was a preparatory meeting before adoption of the General Assembly of the United Nations, and I participated in that panel discussion, which was in the drafting stage of the this cybercrime convention. Now it has been finally adopted, and India is one of the countries accepted that cybercrime convention. Now forensic analysis is very difficult unless you apply the IT or the artificial intelligence. So cybercrime and cyber forensic, both you will find in both this sector, IT and the technological advances and the particularly artificial intelligence is very, very essential. Now social mapping, you know that particularly in the criminal investigation, other investigation is very essential. Document and image analysis. So these are some of the few, actually it will take a lot of time. So these are some of the areas where you can take the help of the artificial intelligence and you can analyze, collect the data and all these things. Now areas of the legal practice impacted by artificial intelligence particularly is there are no much case laws. So though one part of your discussion is one of the case law, but hardly it has been, only I'll give the remarks of some of the judges of the Supreme Court or Supreme Court says about this artificial. But there are no case law because it's just developing. It has not been officially adopted by Indian judiciary, though in some of the countries it has been partly adopted in some of to the Supreme Court level. So predicting policing. So you can analyze the historical crime data. A particular crime data is there. You can say that this is the history. You can predict this can be probable or predictive outcome of that particular case. So it will certainly help in the legal profession. Then crime pattern recognition. What are the crime pattern? What are the modality in commission of that particular crime? That will come to know, and that will certainly assist to help in detecting the particular crime. And surveillance and facial recognition, I mentioned that. Now recent one case after 19 years, because that time IT was not there. That time artificial intelligence was not there. Police had to do manually. And manually they will send their teams various places like that. So it was purely a physical, very tedious exercise. But now because of the artificial intelligence, you will find that facial recognition. So one accused was caught after 19 years, after adoption of this artificial intelligence by face reading. He was watching some particular event, and because of the face reading, the police people and came to know about that, and then he was caught. So this is the greatest advantage, that because of the sensory factors, you can by facial recognition, there can be there, you can immediately detect where that particular person or the accused can be there located. Then voice and the speech. So voice and speech, it can be even identified, it can be analyzed by this artificial intelligence. Then natural language processing, you must be very common and you must be aware about that. Now, with all this adoption of the artificial intelligence, very vast area, I'm just briefly mentioning about the disadvantages, how we are applying this artificial intelligence, particularly in the Indian context. So there are some challenges are there, which has also been mentioned by recently by Justice Chief Justice Honorable Chief Justice Gavi. So Gavi says that we can human this artificial intelligence certainly is very supportive, but it has a lot of challenges are there and it is very risky. And then Chandrachud, former Chief Justice of India, he also said that we should take help of the artificial intelligence. He has taken the help of the artificial intelligence in some of the areas, not in the judgment, but in administrative work he has taken. I will come to that point. So but in spite of all these things, there are challenges like confidentiality and data privacy. Though we have got the Data Privacy Act recently of 2023, still that Data Privacy Act has got limitations. It has not been properly enforced and implemented in this country. And the question of confidentiality is there, where because this, that there is no limit for this data through artificial intelligence. And you are also aware when we are using the chat GPT, we are using this WhatsApp and all these things, almost data has gone through the different server and it can be gone to that foreign country or the source of that particular data collection. Now, algorithm bias and fairness. Algorithm don't understand bias and the fairness. Yeah, he don't know. He'll go mechanically. He don't have that capability like emotions like brain. Yeah. So whatever will give the command, they will collect. What command will give, he will collect like that. So he don't have that much intelligence. Though that's why it is called artificial intelligence. So algorithm don't understand the bias and the fairness. So there can be decisions, can be wrong decision if you are taken on the basis of the artificial intelligence. Then potential for unfair discrimination. They don't understand. We belong to a tribal area. We are not being a percentage poor or like that. That type of the we have not gone to that extent. Probably the scientists and this people, these founders of this, they are thinking about how these emotions and can be brought into that play. But ultimately, I think there will be a lot of limitation for all this, adapting all these things. So accuracy, I mentioned that it cannot be 100% accurate because circumstances while drafting a particular thing here or commission of the crime, circumstances in this country will be different. The outcome and the result of the AI will be the same in India and the America, but their situation will be different. Circumstances may be different. So all these may not be applied, which can be applied by the human mind or the human behavior. So these are the limitation of chances of accuracy is there. So, but that's why I mentioned that there can be 80-90% accuracy, and then you can correct and collaborate with that. And but certainly it will help you. It may not be used, but it will certainly help in coming to the conclusion in analyzing a particular thing in a legal profession. Now, risk of providing inaccurate legal advice. So, if you go through the chat GPT or the AI tool, so they will give particular advice. So they will not mention whether it has happened in a particular circumstances, crime happened in a particular thing, or the particular contractual or the relations were in a different situation. What are the other circumstances probably? So it can be accurate. If you give advice as a lawyer, then it may not be accurate in that case. So that is one of the this risk is there, application of the artificial intelligence. But now adoption of the artificial intelligence in the judiciary, particularly Supreme Court in this country, as particularly Supreme Court has not in justice delivery system, they have not accepted this officially accepted artificial intelligence. But certainly artificial tools have been adopted, applied by the Supreme, even by the Indian Supreme Court. Like SUAS is there, SUVAS, SUAS tool is there, which has been used by the Supreme Court in translating the court documents. Because it's not easy. So translated now we get translation about maybe 27, 28 vernacular languages. So that particular tool is used by the Supreme Court by translating the court documents because so much of the documents are there. Then SUPACE is there, SUPACE, which helps extract facts and the relevant laws. Particular relevant laws on the particular, give the particular ratio descendant topic or the property issues there or the consumer rights, some issues there. Then that you can immediately get these types of the cases are there. Any cases which are against that particular point, we will immediately get the case. So at least this case laws you can collect from these various tools, and certainly these tools have been used by the Supreme Court, Indian Supreme Court also. But though may not be in the justice delivery, but certainly they have taken the help, and naturally on their basis they can speed up their decision making in a particular case. Now, former Chief Justice of India says that he supported and held artificial intelligence potential. He says certainly it has got a potential. Now, unless we use the artificial intelligence, the technology will not be able to minimize the pendency cases and many of the other shortcomings in the Indian justice delivery system. And he always says that we have to Indianize the system. Just like former Chief Justice Ramanna said, or the former Chief Justice Chandra said that we have to Indianize the system. Every time we cannot go by the colonial system. So he said that certainly we should accept artificial intelligence. He held the supported artificial intelligence, but with cautious. See that there should not be misuse. So we should take the precaution or infrastructure, everything should the precaution, because there is a lot of chances of the cybercrime issues and sending preparing the documents. In some cases it happened that they prepared fake judgments with stamp and everything. In Pune court also it happened, and which went to the Bombay High Court. So these are the chances where of the misuse. So there we should be cautious. But he supported that. Justice Gavai said that he warned against the replacing AI with the human judgment. He said that it's not proper, and he cautioned on that it can be supportive, but we should not use that in the justice delivery system. So these are some of the views I have mentioned. Now this is all about how artificial intelligence will totally revolutionize the nature and the structure of the legal profession. Now another factor which will impact the legal profession is the ADR, which is very popular. Everybody knows it's very popular. That long back since 1986 Arbitration Conciliation Act, we have been adopting the ADR. Now this alternate dispute resolution also the object, just like object of the artificial intelligence is to increase the efficiency, minimize the expenditure and the access to justice. Similarly, the object more or less is that here also we want access to the justice, minimize the pendency of the cases, reducing the burden on the judiciary. Now we want to make judiciary efficient, speedy and cost effective, and then preserving informity and supporting economic growth, and particularly access to justice, considering our preamble of the constitution that law should go to the reach of the every poorest person in this country. Then ADR is must, I think, and one of the important factor we should consider, like artificial intelligence. That's why I joined artificial intelligence with the ADR, how they are supportive and particularly help in Indian system in reducing the pendency of the cases and providing inexpensive and justice to the common people. Now these many laws which deals with the ADR in this country is, and that's very common, everybody might be aware, arbitration and conciliation 1996 and amended in 1950 and up to 1921. Now this law, which is based on the conceptual this model and passed by the United Nations. On that basis, we borrowed that and we enacted this law. It was passed by the Parliament, and it particularly deals with the arbitration and the conciliation. And everybody knows that arbitration, two parties appointing one person as an arbitrator, and on the whatever decision is given by the arbitrator, it becomes binding. Only it can be challenged on a limited grounds. In conciliation, with the consent of both the parties, matter is referred, and there can be mutual win-win situation, and they can come to the settlement. But once settlement is there, it becomes as good as the order and decree of the court. So these are the two concepts which are recognized by the Arbitration and Conciliation Act. Now there is another Legal Services Authority Act 1987, and there is very popularly Lok Adalat organized under the purview of this particular law. Many thousands and lakhs of the decisions are being settled by mutual amicable settlement through this process in this country, and help in minimizing the pendency of the cases. Now this Lok Adalat can resolve the disputes, and now there is permanent Lok Adalat, sometimes weekly and monthly Lok Adalat, and also permanent Lok Adalat at the High Court and the Supreme Court level. Then another law which deals with the ADR, Alternative Dispute Resolution Code of Civil Procedure, that's also very popular. Section 89, recent amendment in 2022 amendment. So Section 89 says that the parties up to the order level, they feel that matters should be mutually settled amongst them. Then court has no other option, as per the directions given by the Supreme Court, that they have to settle the matter. They have to give the option to the parties to settle the matter. If parties can mutually settle the matter and submit the memorandum of settlement to the parties, then court has no other option to accept the settlement, and naturally it will be converted as good as order and decree of that particular court. That is there. Then many laws are there. I will mention few of the laws. May not be possible to cover all the laws, but Companies Act, there is a provision. Particular article section 442 provides for the mediation conciliation. Commercial Courts Act 2015 make mediation arbitrary in commercial matters as defined under the Act. Then Family Courts Act, there is a provision of conciliation that you may probably aware about this. Industrial Disputes Act, though one of the old Act 1947, long back when this concept was not there, you will find conciliation has been a important part of the process under Industrial Disputes Act, though it is 1947's law. And then Gram Nyalay Act of recent origin 2008, there is a provision of Gram Panchayat Nyalay. It is sort of mediation, conciliation amongst the villagers in that particular area. And most popular, Consumer Protection Act 2019, repealed 2019. Originally it was Consumer Protection Act 1986, where there is a provision for mediation. For the first time, provision for mediation. I am fortunate to be a empaneled mediator of the State Consumer Commission, High Court and the Supreme Court of India. So I have dealt with some matters of the consumer matter referred to me by the State Consumer Commission, Bombay. And you will find that there is a provision of the mediation, not only mediation, but online mediation is also provided. And now mediation is increased before the consumer court. Then recently there was a confusion because I mentioned Arbitration Act was there, but 1986 Arbitration Conciliation, but there was confusion whether all these procedures, there was no specific precisely mention of the mediation. So whether all these procedure and the applicable to the mediation was not there, and so precisely special law has been enacted, passed by the Parliament 2023, called as Mediation Act 2023. Now this Mediation Act 2020 specially provides for the mediation. It provides for the mediation and even for the pre-mediation. Not only mediation, but the pre-mediation, where mediation means parties can mutually agree to come for the settlement, and then settlement is there, settlement of memorandum is there, which will be sent to the court, and naturally court will endorse it as a order and judgment or the decree, as the case may be of that particular court. So it has got a particular time frame has been mentioned under the Mediation Act, 120 days, and extended further by 60 days. Proper reasons are there. Then Medical Council of India is there in that. Then mediation settlement becomes ultimately the order of that particular court, and they can be challenged only subject to limited grounds. Only limited grounds are there. So no scope like fraud is there, corruption is there, bias is there. So very limited grounds are there to challenge that award given by the mediator is there. And then one of the most important factors is online mediation. Because unless something is there, just like evidence, digital evidence was not there. After this coming into force of the new criminal laws, digital evidence has been accepted. Virtual hearings are accepted. So you have to make the provision in the law. What we orally say may not be accepted by the court. So they made the provision for digitalization of the criminal procedure. And similarly, mediation, whether there can be online mediation, whether any mediation meeting or the proceedings have been conducted online, when it can amount to have the effect just like it has been conducted physically. Now, online mediation has been accepted and recognized under the Mediation Act. That's the greatest advantage. One person in Jammu Kashmir, one person in Hyderabad, one is Mumbai, mediator in Mumbai, he can conduct the proceeding of all the different levels, connecting them, and there can be online mediation without physically going, without incurring the expenses of travel and all these things and hospitality. Then there can be mediation with the minimum expenses. And whatever minimum fees mediation has got, they have got a chart of the fees prescribed by the High Court and the government. That only there will be entire. Otherwise, no expenses will be there, and they can settle. One of the big matters are settled. And I have the experience. I have undergone this mediation process at different level. Now, even judicial activism, unless there is a support of the judiciary in any country, democratic country like India, and then you will find that unless there is support of the judiciary, you will not be able to do anything. So support of the judicial intervention is very important. So in India, you will find that there are one or two cases I will give probably. So of course, infrastructure cases there 2010, and this clarified the scope of the section 89. That is up to the order level. Supreme Court says that then you can send the matter for the arbitration. Arbitration is there. Then one person as arbitrator. In mediation, arbitration consent is required. Mediation consent is required. Arbitration consent is not required. So parties decide like that. Mutual consent matter can be referred, and the Supreme Court says that it is mandatory in that particular case. In some other cases, Supreme Court says that though it's a voluntary process, courts should encourage them, and that's why high courts have given some quota for those district court. They issue this much of the number of the matters should be settled by arbitration mediation. So lower trial judiciary they should encourage the people for coming for the settlement. And in many cases, particularly bouncing of the check, there are directions from the higher judiciary to the lower judiciary that matters should be settled if there is probability of the mediation. And recently, our Honorable Chief Justice of India, Mr. Bhushan Gavai, declared from 1st of July to 30th September mediation moment all over the country, all over the courts, at all levels, up to the High Court level, that matters, there is a probability of the mediation. They have prepared the number of the matters which can be settled by mediation. And recently, I attended one of the this conference of mediation organized by Supreme Court mediators in last week only. And so, the Chief Justice, this senior judge, Mr. Surikant sir, he mentioned that I think more than 6 lakhs of the cases have been identified which are prone to mediation, which are liable to be mediated. And all these cases will be mediated. So this is a great moment and a great initiative by the Supreme Court. So that's why I mentioned that unless there is support of the judiciary, particularly higher judiciary, because otherwise nobody will listen. People will not listen, advocates will not listen, other courts will not listen. So judiciary is very proactive in ADR process, arbitration, and now the mediation. And they have directed that try to mediate the matters, and it has a great effect. Now intersection of AI and ADR. Now both they are complementary. One time we are using ADR. There are many laws I mentioned, and through these legislations which directly or indirectly deals with the alternate dispute resolution, maybe arbitration or the mediation, and matters can be settled. On the other side, there is AI, which is artificial intelligence, where it also helps in settling the matter, settling the disputes at various levels. Another important factor is online dispute resolution. This I mentioned that in Mediation Act 2023, there is a specific mention making the provision for the online dispute resolution like mediation. Online mediation can be there. So online dispute resolution has been recognized by the Niti Aayog and even by the higher judiciary. And one of the instances I will mention, I am the one of the empaneled mediator of the SAMA. And you go through the website or Google search, you will find SAMA Surjo Magar Pyar, that is their theme, slogan is there. And they are the actually alumni students of the Calcutta National Law University, Juridical Sciences, Kolkata. And they established 5-6 years before this organization called as SAMA. And through online dispute resolution, they are settling the matter. And you will be surprised to know that within the 5-6 years of the span of 5 to 6 years, these young people, law students, they have settled more than 35 lakhs of the cases. So this is a great achievement, that settling the matters. And not only that, now government, particularly legal services authority of various states, they are also coming forward, like particularly which includes Maharashtra also, Gujarat, Bihar, Rajasthan. All these states came forward, and they are taking the help of this young platform created by the young students, and they are coordinating with them, particularly for Lok Nyayalaya, online Lok Nyayalaya like that, and they have helped the government judiciary in settling the matter, including Maharashtra State Legal Services Authority. So this is a great achievement, I think, where AI and ADR, they are coordinating with the justice delivery system in this country, and I think it will be a great future. And I always say that future of the legal profession is artificial intelligence and ADR, and that's why I combined both these things together. Now, Justice Chandrachud also repeatedly said that our justice system is heavily burdened. Yeah. Though we appoint many judges, that can be one of the factors for reducing or minimizing the number of pending cases. But we are too much overburdened, and that only by appointing number of judges or creating more and more courts, I think that cannot be the solution. The solution is applying artificial intelligence and applying ADR to the system, and you will find that immediately, just like SAMA has done that, lakhs of the cases they are settling, young students settling the cases, why not we people? And it should be adapted at the college level, it should be made compulsory in the curriculum. Then naturally it is a part of the curriculum, it will go to the legal profession, and judiciary, they probably they may also be trained, because we can't expect even judges to know all these things, because some technical side is there. So if all these we people, legal educationists and advocates and judges, they are trained properly how to apply that, then I think certainly it will be our system, though it's strong system, it will be more and more stronger, I think. So Justice Chandrachud, Justice Ibrahim, and Justice Gawai, they have said that they supported that, only they said they made a caution that it should not be misused. Otherwise, Indian country is more prone. Young people are more prone to criminal activities. Even maybe young lawyers may be involved in there are cases like that. So on one side, there are a lot of advantages, and I think future is with AI and the ADR, with the legal system, justice delivery system, and you will certainly considering the preamble of this country, that justice to all the people and all type of the people, and justice going to the poorest of this country. We feel that we want to fulfill the mandate of the constitution, mandate of the preamble of the constitution, we must adapt all these things, of course, properly with cautious, with properly regulatory measures, with proper legislative measures in this country. Certainly, I think it will be a great future and will help the system, academic field, and also judiciary field. Thank you.
Indeed, sir, it was a really insightful session and it was an eye opener, especially the online tools that you have mentioned, Supace and all others. Those were really helpful. Sir, a tiny request if you can also furnish the links or the list of those online websites which we can
Yeah.
use, that would be of great help, sir.
Yeah.
This